Shortly after starting a medical malpractice case where we sued a number of different doctors, the defense attorney calls me up and says, "Hey, listen, Doctor number 2 did absolutely nothing wrong in this case. Will you agree to let Doctor number 2 out?" Now, my initial response will be, of course not. Why would I let him out if we just sued him along with multiple other doctors? The response really should be, okay, my expert evaluated this case and determined that these 4 doctors were careless. They violated the basic standards of medical care, causing my client harm and injury. Tell me why you believe that your doctor, Doctor number 2, did absolutely nothing wrong in this particular case. And now the defense attorney will then give me their reasons for why they believe this doctor did absolutely nothing wrong. Now, I could take that information back to my own expert to determine whether or not what they're saying is actually true. If my expert agrees, then I might, in some instances, turn around and say, "You're absolutely right, this person should not have been included in the case. Let's go ahead and discontinue them voluntarily from this particular case." However, the better strategy, while the helicopters fly overhead here to downtown Manhattan, the better strategy, in my opinion, is since my medical expert determined that Doctor number 2 was directly involved in the carelessness that caused my client harm and injury, I am often better off telling the defense lawyer, listen, let's do this. Let's continue forward with discovery, and after I've had a chance to question Doctor number 2 during a pretrial deposition, then we can have this conversation again. If in fact it turns out that Doctor number 2 had absolutely nothing to do with causing and contributing to my client's injuries, then you and I can have this discussion again and determine at that point whether what you are saying is true. And if it is, then I will likely go ahead and discontinue this doctor from this case, because there's no basis, there's no purpose in continuing a case against a particular doctor if my own expert cannot support a claim against that particular doctor. In that instance, the right thing to do would be, after learning the deposition testimony of this particular Doctor number 2, if they're right, to go ahead and voluntarily get this doctor out of the case. But what happens now if, after I've questioned Doctor number 2, the facts reveal things that are favorable to us, to the plaintiff, to the injured victim? In that instance, I will have to have a conversation with the defense attorney saying, I understand you still think that the doctor did nothing wrong. However, the doctor testified X, Y, and Z. And based upon that information, my expert has come to the conclusion that this doctor never should have done X, Y, and Z. Instead, he should have done A, B, and C. And had that occurred, my client would not have suffered the injuries that she ultimately did. In that instance, I would be well within my right to continue this case against Doctor number 2. Now, what does that mean? It means that when we are done with discovery, there is a good possibility that the defense is now going to make a motion for summary judgment, a formal written request to the court to get this doctor out of the case before it ever gets to trial. And if that occurs, now we have to oppose that request and put in expert witness information detailing exactly why we believe Doctor number 2 should be in this case and why they were careless and caused my client harm and injury. So why do I share this quick information with you? I share it with you because it's a beautiful day today here in downtown Manhattan, and I had a few moments to share this eye-opening information that hopefully helps you understand how these types of malpractice cases work here in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit, but are still thinking of doing so and still have questions, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.